Tonight, we're talking about a very serious matter, catastrophic injuries and wrongful deaths. And from the law firm of Porter and Maloof, I have Ms. Lorelei Harris. And from Morgan & Morgan, it's the one and only Rocky Wilkins. And we're talking about what to do when that insurance company, who's to blame really, and how to knock on their door and get what you need. Well, our question tonight comes from Jonas. And Jonas has a question about, the cap. Is there such a thing? He says, I've heard that in some states, they place a cap on the amount of money you can win in a lawsuit. Is that true? And what if the amount of your damages is more than the amount that's allowed? So, Rocky, is there a cap in the great state of Mississippi?
Jonas, unfortunately, yes, there is a cap on damages in the state of Mississippi. It was enacted in 2002 and then some more in 2004 in what was called the tort reform battles. And that's where you had insurance companies and medical lobbyists coming in and convincing the legislature to cap damages. The damages are on pain and suffering awards. It's $500,000 in a medical malpractice case, and it's $1 million for everybody else. And so what that means is that a jury's verdict over those amounts for pain and suffering just don't matter. And so a jury could hear a case, say someone who is injured through no fault of their own, gets hit by a semi, becomes a paraplegic, and now has a 20-year-old that now has pain and suffering for the next 20, 30, 40 years. And there could be testimony, there could be corroborating witnesses, medical testimony. Even the other side could agree that, he's going to have a lot of pain and suffering for a long time. And the jury, after hearing that, maybe for a week, 2 weeks of testimony, goes back and deliberates for several hours, and they come up with an informed verdict based on facts and evidence and the law that we believe this young man's life and pain and suffering and a forever pain and suffering case is worth $8 million. Well, that's great, and that's important. It would probably make the news. It would be a big headline. The problem with that is the judge is required, after the jury goes home and goes back to their lives, is required to knock that verdict down to $1 million. It doesn't matter what the jury says. The worst part about this is that we don't tell the juries that their verdict doesn't matter over $1 million. It's a super secret rule of evidence. We basically trick the jury, and we're going to let you decide the case. But if you decide over a certain amount, we know more than you, even though we hadn't heard any of the facts, and you're stuck with $1 million. It's terribly low. Now, on top of all that, the cap was put in place in 2004. It was $1 million. But the problem is $1 million isn't $1 million in 2021 because the price of eggs has gone up, price of milk's gone up. You would need $1.4 million in 2021 to do what the legislature did in 2004 because they didn't put an adjustment for inflation.
Okay.
Lorelei, you think they did that as a mistake, or you think that was on purpose?
I might plead the fifth on what I think the legislature does, but it is real unfortunate. I mean, it's horrible. It's horrible that a citizen of Mississippi can be injured here within the state that they call home and get one result. But if you were just a few miles away in another state, you might have a completely different result. And I think, what does that say about how we treat our own people? It's sad. It's wrong. Not all states have caps, and that just tells you that it's not mandatory. And, maybe Mississippi should rethink how they do things.